The biggest mistake a person can make is actually dying without a will. It's called being intestate. If you die intestate, that means the state that you are a resident of gets to determine how your assets are distributed. Your will covers things that we call probate assets. They are subject to the probate process where you have to go and take the will before the judge, have the executor appointed, and then the assets flow in accordance with the will. There are also assets that are non-probate assets, things like your retirement account, your life insurance, things that have a specified beneficiary. Those are not subject to the terms of the will because they are outside of your estate for probate purposes. They're part of your estate for tax purposes, but not for probate. If you make a mistake in your beneficiary designation, the will does not fix that for you. So when we're looking at a client's estate plan, we like to look at their life insurance, we like to look at their retirement accounts to make sure that their beneficiary designations are correct. The worst thing you can do is if you have a second marriage and you haven't made those changes, you pass away, your life insurance goes to your ex-spouse instead of your current spouse. That's probably not what you had in mind. So the difference between the probate assets and the non-probate assets is a big distinction that we need to educate our clients about. Assets that are titled joint with right of survivorship are also non-probate assets because that designation of survivorship makes it outside of the probate estate because it passes to the survivor as an operation of law. So that's also a non-probate asset that people don't think about. Most of us have our houses titled with our spouse, joint with right of survivorship. So even if the will says, I want to leave my personal residence to my children, it doesn't happen that way because it's not a probate asset and not subject to the terms of the will. Another mistake that we see is not accounting for assets in different states other than your state of residence. So if I own property in Florida, it's going to be subject to probate in Florida as opposed just to a Georgia estate. We also see taxpayers who move, like if you retire and you've always lived in Wisconsin and you move to Georgia, you need to update your will to make sure it's under Georgia law if you're going to be a Georgia resident. Sometimes executors don't necessarily follow estate plans. We want to make sure that the estate plan is clear enough and gives enough direction that the executor can follow your wishes and it not be circumvented. An effective estate plan can prevent many headaches and many family issues after you're gone.